be interested to know what you guys think of the case of cannon and poultry harvesting. Obviously, the main error that the employer made was a breach of procedural fairness. I think one of the themes that I've seen a lot with employers who would otherwise do the right thing but are making huge mistakes is when something that really upsets them happens. It's like the death of the chickens, and that has led, I think, if on the evidence that it was accepted, the employer to just lose it and terminate without following process.
And I think it's something that employers often jump to. Something terrible happens in the workplace and they think, I've got an entitlement to terminate. But they need to be aware that they have to take it through a process of actually determining what happened, because from memory this occurred at sort of 2:30 in the morning and there was no one else on site. So actually seeing what happened, going onto site, interviewing the employee and formally putting them to her as allegations, I think would have seen a very different outcome in this case.
Absolutely. And the critical thing when you look at it is ultimately the Commission found that he did terminate her, the employer. If he had terminated the next day, it could have been a totally different outcome. I mean, we don't know whether it's how much is on the time of the dismissal and how much is on the policy issue. Yeah. That's what's hard to tell, but I tend to think it almost, because she did do the wrong thing, it's almost the combination of both that's got them into trouble.
I mean, what was the policy that was in place?
They had a policy in place about alcohol usage, but it wasn't necessarily a zero tolerance policy, and they didn't enforce it, so they couldn't seek to rely on it, that she may have been drinking and that was the cause.
The status of the document, they obviously said during the case it's a policy, but as is so often the case, what does that really mean? The fact that they've got a document somewhere in one of their files in some office doesn't make it something that the employees are having to, comply with or believe genuinely as they go about their work is going to be applied. So really, to get a document to the status of policy for the purposes of an unfair dismissal case, you're going to need to not only tell the employees about it and make sure they understand it, but apply it fairly throughout. When there wasn't a catastrophic incident in the workplace, the fact that someone was drunk might just be a warning.
Look, I think they had a real argument that it could be considered serious misconduct if they had gone properly through the process. Someone else's chickens, so they had a client reputation issue, which falls within the meaning of the regulations, that certainly could have been considered if they've gone through the proper process and had looked at the policy closely and done things like, testing or questioning her about
and questioning her.
Consumption.
That's right, and it's one thing in the case to rely on the fact that she didn't drive to work that day because she thought she was affected by alcohol or might be RBT. It would be a different thing if they put that to her in a proper interview and she said, that's why I didn't drive to work, and they'd said, well, don't you think in those circumstances you shouldn't have been working or operating machinery, and that would have put them in a much better position.